host right away so that if there's anything you need to clarify, you clarify, because there are no questions for now. There.
Okay. So one of the, maybe I'll speak on the possible impact to African businesses. Let me first of all share my screen. So one of the possible impacts on African businesses, like I said, was the lacking out on investment. The second one was with the enactment of the African Continental Free Trade Area Association, whereby the entire Africa will be able to trade using the free trade area policy. So we'll no longer have ECOWAS, SADC, COMESA, and all that. Will be one entire regional bloc. So to ensure you're not left behind as a country, whereby your domestic businesses end up being consumers to the other developed countries such as South Africa, which we know is a leader in Africa, whereby they become the major producers in this business model of the AfCFTA, and the rest of the Africans become mere consumers, which leads to dwindling of our domestic businesses. So one way we can stay ahead is ensuring we are GDPR compliant. On my work, I've shared a link whereby you can see the list of African countries that are GDPR compliant, and Kenya is one of them. So I'm confident that if businesses are able to undertake this, like in the Act, they give the provision whereby every business should have a data protection officer. The data protection officer will be conducting data protection assessments, whereby when they are collecting data, they're able to give sound advice on how to maintain the data, how to collect it, and how to distribute it. And once they're done with what they are doing, how to delete it. So you must delete the data as a company once you're done what you're aiming to do. Thirdly, they must take adequate precautions. They must take adequate precautions to ensure that all software is designed or is either categorized as having access to personal data, to ensure that it is not a threat whereby even someone can be able to hack and get such information. And it's not just hacking. Even one of your employees can go home with her laptop and it has contents of personal data of some of your customers. And another person may fish out the information and use it for other purposes. Now, once the data subject comes to the company and asks, why did my data get lost? Or how did this other company get possession of my data? Now, therefore, you cannot put the blame solely on the company, because this was through the efforts of the other company that stole the data. So that's also another factor that has to be considered in the Act, because they put strict liability on the data controller, yet the data controller at times, the information may be lost without their knowledge or authority, maybe through hacking.
Let me interject. Can you give us
Yes.
a practical example? So if I have, so who's the data controller, who's the data processor, who is the consumer, all those?
The data controller is anyone who collects personal data from somebody called the data subject. Now the data subject is the one who owns the data, the personal data. So, and like I said, when we speak on this topic, somebody may be thinking you're only speaking about Google, Facebook, or all that, but it is anyone who is collecting data. And it's just that it hasn't been implemented yet. The Act even provides that you must have the commission, the data commission will have a register of all data controllers. This is to mean even websites may even be shut down for failing to be compliant with the Data Protection Act. Once we go on and the implementation, the Act is implemented fully, because as at now, we haven't seen regulations on the same, but people are bringing out cases and bringing complaints to the commission, such as the example I gave on the political parties. However, in the Act, it provides an exception whereby you can use data to a third party where you consider it was in public interest, or maybe it was under a very, very, very special circumstance, which I believe the Register of Political Parties will use in this regard, whereby they said the reason why most people found themselves themselves registered in other political parties was merely because they were conducting a trial. So now that is a special circumstance that falls under the Act. So there they may go scot-free. But in the event that data is lost from anyone and a case or a cause is brought from it, you will be held liable and strictly liable for that matter.
I have a follow-up question. Now to a lay person, to someone who hasn't done law, how would you interpret the Act for them, and how does the Act affect them?
The Act affects them in the sense that they have to realize who a data controller is, and a data controller is anyone that accepts data. So that's the first step. So when your business undertakes the information of collecting data, and most businesses which I know, they may even be unaware, are property companies. Like let's say a landlord who collects your numbers, your names. In the event that you start finding some promotional messages from other companies, then you can hold the property company to be liable for having shared your personal information with other third parties. And once you, like in such an example, once you vacate the house, they must delete your personal data on the same. Maybe they can maintain it due to the provisions of the Company Act that holds records must be kept for a certain period of time. But in relation to the personal data, they must delete it.
Yes, thank you. A follow-up question. Okay, there's someone saying he's trying to enter, but they can't. Maybe if there's anyone in the lobby, you could admit them. There's
okay. Where's the lobby?
Okay, are you seeing anything like? Okay, I think. Okay, he's just texted me. He's trying to enter, so maybe you'll see. No problem. So, a follow-up question, still to the common mwananchi, the one. How would you advise him or her, with regards to using the internet for, using the internet? How should the common mwananchi protect themselves against cyber crimes or those issues of cybercrime? After that, Tony will speak. Thank you.
One of the ways people can maintain a safe environment within their private sphere as they interact online would be pseudonymity. Pseudonymity is whereby you are able to mask yourself, which is provided for under the Act. One of the ways the Act provides that you can safeguard data, personal data as a data controller, is through pseudonymity or through encryption. On encryption, I gave the example of WhatsApp, which is end-to-end encrypted, and then there's pseudonymity, whereby you mask yourself, which then begs the question, or is using a VPN legal? Now, under the Act, the Data Protection Act, I can say yes, it is, because it is allowing you to maintain your privacy through pseudonymizing your location, whereby rather than saying you're in Kenya, it will say you're in another location, which then prevents the sharing of third-party cookies to other websites. Yes, Tony?
Tony?
Yeah, so I'm just wondering, Rogers, and I'm just trying to pick your mind on this. Do you think that maybe the digital space would require a lot more policing? Because like you're saying, the registrar of political parties may get away with having potentially shared people's data by saying that they were conducting a trial. And who's to say that it wasn't a trial, that they actually shared the people's data?
Yeah. In such an
Go ahead. Sorry.
In such an instance, like in the example of the register of political parties, it would be at the discretion of the court whether or not this was a special circumstance. And from my reasoning, I can say it was a special circumstance. But when a party feels they are aggrieved by this, they are at will to go to appeal the decision of the data commissioner and go to the courts, whereby they can also get redress on the same.
So,
Thank you.
So just a follow-up. So
Yeah.
do you think that maybe citizens need to educate themselves more on data privacy, or maybe more policing on the digital space needs to happen?
The issue is the education. There needs to be enough educating, and it has even been outlined in the Act. The Data Commissioner has the obligation and duty to ensure that the Kenyans are educated on data privacy. Because if they started policing it today and start saying that they are going to fully implement, many websites would be shut down due to this. So they need to conduct adequate education on data protection, especially to the data controllers, because you may even be somebody just with a form roaming around, or even a marketing company just collecting data from people, but then you share this data, or this data ends up being in the hands of a third party who uses it to their own advantage. Then that becomes a problem. Like you saw the issue with Cambridge Analytica and Facebook. And the reason why they were mainly dealing with the issue in the context of the US election is, like I said, the Data Protection Act in Kenya does not fall within the scope of application of data, personal data collected outside Kenya that is relating to Kenyans. So that is one of the major policies they need to add on the act. Maybe it could be in the form of a subsidiary legislation for it to take effect, because then this act cannot just be confined to us within Kenya. Yet, as you know, the internet, you interact with several servers or several, what do I call them, service producers from various points of the world. So these people may be in another country collecting data from Kenyans, then they get away with it just because it's not within the ambit of the act and you cannot get redress locally. That's also another factor.
I have a follow-up question. Who is responsible? Sorry for interrupting you, Tony. Who is responsible? Is this the Ministry of ICT, or who is responsible?
So the Data Protection Commission is under the executive. It's a body under the executive. They've tried to state in the act, they state that it shall be an independent body, but being under the executive, I don't see whether that's really completely independent. Because as you know, in the Cambridge Analytica case, whereby they mentioned Kenya, one of the people who are being targeted was the current president. They alleged that he also used Cambridge Analytica to his advantage to manipulate people's decision-making during the elections. However, this has never been proved yet. They are mere allegations. I should say that as a disclaimer.
Thank you. So I have a question. In the recent past, we've seen MPs and people in the public figure having their photos, like let's say nudes, in the media, or yes. So do they have a recourse in court if you share your private photos? Do you have a recourse?
Once your private photos are shared, you can have recourse because you know whomever you share the private photos with. So you'll have recourse against them because that is sharing your own personal data. But in the event that you posted them for the public to see, then I don't think you'll have any recourse from that because it is already public information. It cannot be categorized as personal data.
These people, sorry.
Yes.
Can you hear me? Okay, these people called, what are they called? Akina Edgar Obare. I'm sorry, I can't remember. What's the name we give to them?
Yeah.
Tea masters, or yes.
Bloggers.
Yes, bloggers. So people send to them their issues and then they post them. So is it legal to be a blogger like Edgar? And we have seen in the recent past that he's been sued. He's been having court cases because of the nature of his job. So what do you think what do you have to say about that?
In such an instance, I believe it's where people share their personal data. In such a case, the media law will have to come into place. And I believe one of the reasons he uses to justify what he does is the media